Hi, I'm Gaucho Rasmussen and I'm an Enforcement Director at the Competition and Markets Authority here in the UK. Welcome to this masterclass on pricing issues from a competition law perspective. Today I'm going to take you through both what the CMA does and its strategic goals, and second I want to talk to you about some very specific pricing issues that may raise competition law concerns. It's not just consumers, not just the economy, but it's also making sure that businesses are able to compete fairly and freely in a well-functioning market. And we want to extend the competition law frontiers, ensuring that competition law applies in all sectors of the UK economy and that it also applies to ever-evolving and new business models. That is particularly important in the retail sector, where we are fully aware that things move very, very quickly and new business models emerge almost on a daily basis. You may face fines of up to 10% of your worldwide turnover. But there are also personal risks if you enter into specific prohibited competition law infringements that may lead to you going to jail. Moreover, company directors may be disqualified from acting as a company director for up to 15 years. In the fast-moving retail world, trends come and go, but retail price maintenance is and remains a classic. We had another case where we looked at a restriction imposed by the manufacturer where they said that the retailer could advertise prices online, but these prices must not be below the recommended retail price. Again, we found that this was an unlawful restriction. Another area that is of continued interest to us is so-called dual pricing systems, where one price is made available for the same product in store, in the physical store, and yet another product online. Most favoured nation clauses can have very many different forms, and the ones we've been looking at in particular is where you have, say, an online sales platform requiring people using that platform for selling their products. So let's take the example of Amazon, requiring that those vendors do not offer the same product for sale cheaper on other platforms or elsewhere or through their own websites, for example. At first blush, you can see how this has certain benefits for consumers, that they go online and they can assume that they're being offered the lowest price. We might be concerned that if we see that price guarantees actually soften competition between retailers because it removes the incentive to lower prices if you know as a retailer that your competitors are going to follow suit immediately. Anything you say to one particular authority is very likely to be heard by others. Second, what you probably want to think about is if you spot a trend in the retail area in one country, that is very likely to also emerge in a number of other countries where you are operating. So even if you see a company being investigated for a particular type of pricing practice, for example, that you're engaging in, do think about how that would play out for you in the countries you're operating in. In a particular sector, you could imagine that there was a really good economic and objective reason for having that restriction in place. And I would say to businesses, if you have something like that as part of your commercial strategy, do think about what evidence you have to justify that particular restriction. We want to make sure that we understand your business, but that you also understand where we're coming from in terms of seeking to enforce the competition law and consumer protection rules, thereby ensuring that markets work well for consumers, for the economy, and for businesses such as yourselves.